on the 11th December, my another case is fixed on the same subject matter. So for releasing,
Therefore, listings give to the court master, please. It may not be listed this week, or listings may be in the next week only. Yes. If you want listing within this week, then you have to make a mention tomorrow. Because my bench is not there tomorrow. So I will not be listing matters before any other bench. If you have an urgency, please move it tomorrow. If you can wait for a week, then next week listing will be permissible. Yes. 39. Change करा दो। मैं पढ़ने की आते हैं तो लोग खड़े हैं। हम ऐसे यहाँ पे रिपीटिंग जो करना होता है। Yes, item 13. 39. Yes. No, you respondent 2 you say has mental illness. What is your instruction on the matter? Can I see the instructions? Please pass it on. No, those things won't do. It's a hearing matter and a matrimonial application. On the ground that respondent 2, you said that he's suffering from she's suffering from mental illness. So if that be so, you show us the instructions. It can't be that you have oral information and for that you will pay for adjournment in the 2018 matrimonial matter. You will not permit that. You see, you must show substantial ground to take an adjournment in a 2018 matter. This won't do. If you have instructions which is there with your client, let him ask to keep it in the safe deposit vault of a bank. Correct. Keep it very secure. Because if a counsel accepts oral submissions of mental illness, that will not be permissible. You show us and pray for an adjournment. When the matter is listed, even then you can show me a document, well and good. Otherwise, I am not adjourning 2018 matrimonial appeal on an assumed ground of the respondent being mentally ill. Correct? That is refused.
Number 2.
Item number 2. Item number 2.
Yes, Lord.
Item number 2 is Mr. D.P. Shalia.
Yes. He's an out of state.
He's out of station. Okay.
I think it's from January 1st. First week of January.
Okay. On the prayer made by Miss M. Roy, counsel for the appellant. Matter stands adjourned as the senior counsel for the appellant is out of station. List in the first week of January as paid for. 2024 as paid for.
please, but you have to mention item number 11 and item number 20.
One by one. Item 11.
Item 11, let's see.
Yes.
We have some personal difficult discussion. Can the matter come up after your results?
NCB, you have informed the other side. Item 11, he's paying for adjournment. NCB,
NCB,
you renew the prayer when the matter is listed. Without consent, please don't make a mention. It's something I dislike. Correct.
Lordship.
You put yourself in a position where item is item 50 at 3:30, 4:30 when it is taken up, then you are informed that the matter has already been adjourned. Would you like it? If the answer is yes, we'll adjourn it. But you'll have to file an affidavit that from today onwards, you will never make a objection if anybody takes ex parte adjournment against you. It's a personal affidavit from the lawyer. You file it with the registry, we'll keep it as a matter of record that henceforth you will not protest against any adjournment taken ex parte. If you are prepared to do that, we'll adjourn it now. Correct? No ex parte adjournment. You put yourself in that position, whether you will like it. Correct? You had it, you could have informed the other side. Ex parte adjournments is not permissible. It shows disrespect of you to the other members of the bar. You do not have any respect for your brothers and sisters who are in the bar. It's something I dislike. Yes,
Yeah.
Mr. Sharma, yes.
I'd like to mention one review application here, right? That is more than 1.5 years old.
You give it to the court master. If
Maybe
you-
on 6th, 7th or 8th of this.
this week it will not be listed. If it is in the next week, you can give it.
Yes, it may be in the next week. Yes,
Give it to the court master.
next week. Yeah.
Hmm.
Okay.
Yes.
Lordship, regarding item number 12, Lordship, there is a bail hearing. I have informed the petitioner, we have not received the case diary, Lordship. After that case diary was called for, and I have informed the OC also, Lordship, concerned police station, and they will produce within a short period. So, Lordship, can I have
Okay.
informed them.
Monday then,
Lordship,
item 12. With consent of the other side. Ms. A. Begum, then at counsel for the, then APP, placed for adjournment to produce the case diary. First off. Matter is adjourned, list on.
Twelve.
Next,
11,
no, 11, 12 for production of case diary.
obliged.
Yes,
Number
8. Oh, I see. Okay. I get it. Both sides are represented. On the prayer made by Mr. P.S. Dekar, senior counsel. For the appellant, the matter stands adjourned to enable him to append annexes to the plaint by filing additional affidavit. List after 2 weeks. 8. Yes.
Item number 18 already settled. And maybe it's on 9th of Rotagala. How should the court be settled?
18th,
18 and 23.
18 and 23.
May fix on,
No, we are not fixing it. Let the other side be here. Because ex parte, I'm not doing it. Ms. Bhattacharya is sitting behind. I think your matter. Oh, not her. Okay, I'm sorry. Ah. Yes,
Release item 1 on offer.
yes. Just a minute. You're the petitioner,
I'm the respondent.
you're the respondent.
The Indian order, Connection Act, page 40. The 11th paragraph starts from page 41, last line. Last line.
Yes.
Why they oppose the petition number suspension? Opposing party number 10, Srimati Anita Gai has placed a rejection. And the petitioner directing the concerned police to inquire about the whole matter involving the will as to how money was withdrawn by the petitioner without any order to be confirmed source from the various banks. Post office without originally belonging to the translator. It is the contention of the petitioner that the petitioner has filed a certified copy of the will and that no reason has been assigned as to why the will original has not been filed. That the balance of the account has not been detailed by the petitioner in his petition. Serving account number suspension has not indicated death certificate of the disease is not enclosed. Detail of income and the address of the petitioner are not provided. No details or amount of rupees fixed deposit, previous MI share, details, sale deed, etc. lying in the different bank and post office are enclosed. Further, it does not mention about the share of the wife, disease and the that order 7 is the order 1 is the order 7 1 GI and order 7 8 are not followed. Therefore, according to her, the petitioner to be given that her has failed to make out about notice and does not entitled for any conservative claim of the probate. Opposing the efforts of prayer petitioner given has submitted written objection, looking among others that the petitioner is not affected by Rule 7(1)(b), apostrophe 8, and also order 7, Rule 11, and petitioner is put by section 276 of the Indian Constitution Act. Here, my main contention is that the original rule was not annexed, and the learned district judge discuss elaborately, it says that original rule is not required. While there's a mandate of the law, in 276.
No, you see, what you call, the will can be produced at a later stage also. And it will be kept in the safe custody for after inspection. So you could have molded your review by asking for the production of original for inspection. You see, we all have our what you call share of experience in courts. The documents get destroyed. The
No, my part is 276.
no 276 is a will annexed. If it's a copy annexed or
It was said, bequeath. 276
it
says
says a will.
the will. The will means the original will because the other.
No, it's okay, but you see, if I'm filing a copy thereof, 2 copy thereof, what is wrong in it?
And the second point is that will the profit was filed beyond limitation period, after 11 years, which was barred by law.
Where is the ground taken for barred by law? Where is your petition?
It is page 22,
22.
or written objection, where I have filed, page 22,
Yes.
The testator, or Srinivas Kumar Sura, paragraph 5, was died on 9/12/2008. And the probate proceeding was filed on 2019.
No, that is okay. That's a defense taken. But you see, on a point of limitation, either you pay for a point to be raised as a limit period of for issue of limitation. Then there are 2 exceptions. Number 1, if it's a mixed question of fact and law, then perhaps on limitation, preliminary issue may not be adjudicatable. But second is that if the limitation can otherwise be discerned from the pleadings in the plaint, then it can be taken up as a issue of law. Because in the preliminary order, in the preliminary order, the court will only say that this petition is otherwise acceptable, and then it is to be converted into a suit if it is contested. So that will be the first order on contest.
Yes, we have contested, my lord, and it was proceeded, my lord. Therefore, my application has been rejected.
Right.
Stating that will is not required, but the mandate of law is that a will is, original will is required to proceed with it. Otherwise, how can I file, my lord, my objection, my lord? Without having the original will, without having the documents, nothing has been produced, my lord.
Shows the probate, the application of probate. Where is that? Where is the probate application?
It was started from NXRA, my lord. NXRA is the proper application. My lord. We also filed the application to produce the document, provide us the document. That also rejected.
Is your application for production of document?
Well, my lord, that was page 27, NXRC, my lord.
27 is rejection of plaint.
Page 27, my NXRC.
That is rejection of plaint.
Here I have played, my lord.
I mean, rejection of plaint, you can't make a composite prayer.
My lord, paragraph 3, my lord.
No, statement is okay. But you see, if you make a prayer in that application, the court proceeds under order 7 to 11. If there are other prayers, and when this prayer is otherwise rejected, in an application for rejection of plaint, can the court adjudicate any other issue raised there?
Here look at NXRD, my lord.
No, because you see, I'm putting.
NXRD, my lord,
Exactly.
specific prayer, my lord.
Yes, this is prayer directing the petitioner so and so to furnish detect of document. What is detect?
All savings bank account, my lord, post office account details, all CGS property details, all property details, moving immovable properties, my lord. And the death certificate of the disease, my lord, that was also not provided, my lord.
Is somebody disputing that the man is dead, not dead?
That was not disputed, but for that, my lord, the document, original document, as well as the will, my lord, has to be produced, my lord. I have not seen, madam, whether that was will or signed or not, my lord. For probate proceeding, my lord, the attested witness's signature, the testator's signature is necessary.
Just a moment. You are requiring savings bank account, post office account, fixed deposit details, details of furniture, death certificate of eldest son, locker, all information of savings bank. Question of production of document and inspection of will is not even prayed. Please come to that order once again, infusion order.
Order, my lord. So started page 42, my lord.
No.
My lord, kindly look to my lord, 276 of the Succession Act.
Mr. Shiladitya, come to page 42.
Okay.
Last paragraph. Opposing the prayer, aforesaid prayer, petitioner so and so, last 3 lines it says, it is further contention of the petitioner that he has explained the reason as to why the certified copy of the will has been submitted along with the petition and the original is still in custody of the registrar office. Correct. So therefore your contention before this court that no will was annexed is false. Second, the certified copy was produced. And if the original is still with the registrar office, it can only be produced by way of issuing a notice under Order 16 Rule 6 for production of documents. So can a application for probate be fatal just because the certified copy of the will is there?
Because my lord, 276 says, my lord. May I read the 276, my lord?
Don't read it. A copy is there. It's a certified copy. Presumption of correctness of the certified copy is there. You want to prove the signature, but your prayer for calling of the document doesn't say that.
For
You see, you couch your prayers in a petition which is hidden. Under 7 Rule 11, you file it. And in 7 Rule 11, the court will only say that these are parameters are there and therefore plaintiff is not rejected. Then you come before this court saying that in that petition under Order 7 Rule 11, I have made a mention that a document was not produced. But production of document is not something which is designed to be contained within the meaning of Order 7 Rule 11.
my lord, my lord, subject, my lord. In the probate proceeding, my lord, the original is to produce the original is must, my lord, as per 276, my lord.
Does it say that certified production of certified copy would be fatal? Have you any authority by any court in the country which says that production of original or certified copy would be fatal because of non-production of the original?
Yeah, may I read?
No, I have read it. 276, I have read it more than one time.
It was said, my lord, the will annexed, the will, my
The will annexed.
the original will, my lord.
If I don't have the original, then what happens?
They cannot file the probate proceeding, my lord.
Unacceptable. You have to reject your petition in limine.
And the my lord, limitation period, it was, my lord.
The limitation is something else. You have to raise that application for limitation as a point of contention.
My lord, as per my understanding, my lord, the original will is required to produce the file.
No one says that, but he has explained why it would not be produced. Certified copy is there. You can ask for inspection of the original.
So they not able to produce the original, my lord. They said that it was before the registry and it cannot produce, my lord. They are certified copy has been produced. We have to, my lord, tell you, my lord, whether the witness was signed or not. Therefore, in probate proceeding, the original is required, my lord.
We have not made a prayer for inspection. You see, copy of will can be always produced. Today, if I file an application with a certified copy under the Evidence Act 76 of the Evidence Act, is the what you call the production of certified copy, will it make non-production of the original will fatal if I don't have it?
But without being the original, my lord.
That's a question of proof of signature. Whether it was signed by someone is a question of proof of a execution of a document. Not a it can't be disputed that there's no will in existence. A will may be a forged will. You see, instead of A, B must have signed it and give it to the sub-registrar for registration. It's a forged signature, but forged signature is a defense.
My lord, may I read the section 294, my lord?
Yes.
294, my lord. Filing of original will, of which probate or administration which will.
Just
annex
the Succession Act. Has any court in the country interpreted it by saying that certified copy was inadmissible?
My lord, as per my lord, knowledge, my lord, this is required during probate proceeding, my lord. The original will has to be produced, my lord, annexed. Therefore, it was mentioned the original will, all the details, my lord, which has to be state, my lord. And section 294 therefore, my lord, state, my lord, the district judge and district delegate shall.
Mr. Shukla, that doesn't impress because of the fact that when you are referring to this, please also refer to section 63 and 65 of the Evidence Act. It says that if a satisfactory explanation is given, you see, for example, in a civil suit, if somebody claims right title interest, he will have to show his title. He'll have to produce the original. The law says that before settlement of issues, the document has to be filed. Correct? But somebody doesn't file the document. So will it be so fatal? What happens to section 63 or 65 of the Evidence Act?
For the public proceeding, it is fatal, my lord, because in
No,
the,
then this
Therefore,
can't be the, you see,
there,
this in the history of the court in the country, it can't be the first case where certificate copy is produced and not the original one. Some court must have interpreted it that certificate copy.
Every district judge or district delegate shall file and preserve all original wills.
Correct. For that we have fireproof safe.
All
This is the only requirement because of which in the courts, civil courts, there is in the custody of district judge, there is a fireproof safe.
all original, without having the original will, how the court will preserve, my lord.
No,
Therefore, the production.
no,
of original
we,
must-
you are on the second point. I am on the first point still. You see, if the court orders an original, in spite of this to be original to be produced, and that is kept produced before the court, it goes into the safe custody of the court, number one. Now, if supposing the original will is lost, he says an application that the will was executed in year so and so. Certified copy was available with my mother. She gave me in the year 2019. Correct. Now he has a certified copy. Let us say that he did not take any initiative to get the original. First is that he does not say that his mother also gave him the registration receipt. Now, without registration receipt, it may not be permissible for a sub-registrar to part with the original. And if he doesn't part with the original, it is only the summons of the court under Order 16 Rule 6, which will require him to produce the original before the court. Once produced, the court can have it into the safe custody. Now, please tell me if I am wrong anywhere. Without a certificate copy, if you could have asked him that please produce the original receipt. If the original receipt is not there, he says that I can't get it. Then the court must presume that the only alternative that a petitioner who does not have a receipt of registration or the original copy of the registered document will have to go loot the commit theft or loot the sub-registrar office, steal the document
That
and
is-
produce it before the court.
that is the other part of the petitioner, my lord, they have to prove.
I don't know. That's why you see, I'm asking you.
They are
I'm asking
signature-
you.
Yeah, that is their part, my lord.
Mm,
I don't need to be proved, but I have to question their signatures and the execution of the will, my lord. Now, without having the original will, how can I, my lord, say that whether that was executed or not, whether
No,
that was signed or not?
This will be rejected in limine. We'll give you liberty if you want. A plea of limitation can be raised, number one. Number two is that if the original is not there, you can always ask the court for production of original. That liberty will give you. But the rejection of plaint will not be permissible because otherwise I would dispense with section 65 of the Evidence Act saying that and 76 of the Evidence Act saying that certified copy is inadmissible. That would be too hard to do it.
My lord, provide me some time, my lord. I will try to satisfy your lordship, my lord, regarding the production of original. It's a question of law, my lord, because whether 217 were interpreted properly.
I know that. You see, I asked you that question. If there is any law in the country which has said that this is fatal, if it is not there, if I am the first court to author that, let me author that and clarify.
Can you allow me some time? I'll
Okay.
try to satisfy your lordship.
Next Monday then.
Yep.
List on next Monday. As split for Mr. Shiraj and counsel for the appellant.
Obliged.
জানেন না এখন? জানো জমা তো হবে। Item 3. Transfer. what is the ground, Mr. Kakoti?
Grounded. Page. Is 8 also. Page 5, there are 8.
Just tell me.
Okay, the divorce proceeding been filed by the husband against the wife. The happy and wife resides in Lausanne. So that it is difficult for her, and just can you produce the para 8 and reading
Para 8.
para 8, page 5.
Yes.
That the petitioner directly stated the petitioner having no source of income to maintain herself, and she is completely dependent on the income of her father, who is a porter. Her father has no sufficient income to give financial
Okay. Heard Mr. G. Kakoti, counsel for the petitioner. Is it divorce petition?
He was filed by the husband.
Okay, divorce petition filed by the maternal dispute, divorce petition filed by the husband. Notice steps, take steps within 2 days, returnable in 4 weeks. The petitioner claims. Yeah, I heard the learned counsel for the petitioner on the prayer for intermediary. Just the petitioner claims that she is dependent on her father, who is a potter, and has no sufficient income to give financial assistance to the petitioner. He traveled from Bajali to Guwahati which is about 200 kilometers, to attend court proceedings. It is also claimed that the petitioner has filed a domestic violence case against the respondent, which is registered at DV case number 28 of 2023, pending before the Court of Learned Chief Judicial Magistrate, Bajali at Pathshala. Accordingly, proceedings of so-and-so page 1, state, subject to production of certificate copy of this order before the Learned Trial Court, to bring the order to the notice of the said Learned Court. This after 4 weeks. Yes. Okay. Which page is the Indian order?
Well, page number 58, man.
58.
Can you look at the last question, my lord? At page number 41, without discussing, my lord, as to whether there is sufficient grounds or not, whether there are formal defects or not. Straight away, my lord,
But Mr. S. Das, counsel for the petitioner, learned counsel for the petitioner. By filing this application under Article 227 of the Constitution of India, the petitioner has assailed the order dated 31/8/2023, passed by the learned civil judge within bracket junior division, bracket was number 1, Bopeta, in Michi case number 175 of 2023, in TS 71 of 2017. So by the impugn order, the learned trial court had permitted the respondent plaintiff to withdraw TS 71 of 2017 with liberty to file afresh. The learned counsel for the petitioners has submitted that in the impugn order, the learned trial court had not discussed the essential requirements of return of plaintiff with liberty to approach again. which includes the nature of formal defect for which the suit would fail, and why the claim could not have been amended. Explanation notice returnable in 4 weeks. Steps within 2 days. This is a notice. You can notice on the prayer point of view as an interim. The order impugned in this, the order dated 31/8/2023. Passed in this case, passed by Learned Trial Court in Learned Civil Judge Junior Division number 1, Bapeta, in Niji case number so and so in TS number so and so shall be subject to further orders that may be passed by this court. Next paragraph. The petitioner is at liberty to produce the copy of this order before the Learned Trial Court and or public the court in which the fresh plaint is submitted by the respondent. List after 4 weeks.
Highly obliged.
5.
Item 5.
Just a moment, Mr. Das. Just a moment. Where is the previous MSCT application? Where is the previous MSCT application? Where is the previous MSCT application and
Yes. I have not made the copy of the petition,
shows that
MSc application. I have annexed the copy, the copy of the reviewed petition.
no. We wanted to see your claim petition, previous claim petition. You have a copy of the claim petition based on which you filed this review application. In your custody, do you have that application, the copy of the earlier MSCT application based on which you have filed this review application? Do you have a copy?
I have not received the copy from my client.
Then your application would not be maintainable. It will be dismissed in Living.
So I may be giving some time to file the petition.
No, that will not be permissible. Because if you, who is the counsel who has filed this review application?
Yes, madam. The review application by SC বিশ্বাস, Learned Council, SC বিশ্বাস has filed it.
So you get it and show us by 2 o'clock.
My lord, actually, my lord, a petition was filed by one.
No, you see, Mr. Das, this is a litigation we will not encourage. The reason is, I am telling you the reason why I am thinking so. I may be wrong, but this is the thought pattern which I am having. I am just sharing it with you. You see, you file a previous MSCT application.
Yes.
And make a claim, and a claim petition is adjudicated. Some
lord,
orders are passed, correct?
I have not filed it.
No, it's okay. You have not filed it. But somebody must have given evidence in the case.
My lord,
Somebody must have,
I was the respondent opposite party in the MEC application. But I was the respondent number one, I was the opposite party number one in the MEC application matter. And on my behalf, one Shri Upendra Nath Chetri filed a petition for adjournment,
where is that copy?
for granting some time made.
Where is that copy?
Copy also not in that. So
you-
against him, we have filed an FIR matter. Before the problems are finished.
No, first of all, you see, somebody must say that this petition is not filed by me. This adjourned petition is not filed by me.
Yes,
The Vakalatama has to be there. So, you see, how I'm satisfied that somebody, some imposter got an adjournment petition filed on behalf of respondent.
yes, ma'am.
How do you arrive at a prima facie? How do you satisfy yourself prima facie?
My lord, it was annex, my lord, not in this application, my lord. Along with the review petition, my lord, the petition was annexed at page 21, my lord.
Page 21.
A photocopy of the Vakalatnama dated so and so is annexed here. It is annexed, and there are 8, my lord. Annexed, annexed along with the petition, my lord, and it is submitted before the learned tribunal below, my lord.
You have a copy of that FIR?
Madam, also, I have not annexed, but it is
No,
mentioned,
no.
my lord. At para 9, my lord.
No,
Okay.
you see, this para 9, unless there's a document appended, how do I record my
All
satisfaction?
these, the affair, etc. will submit it before the learned tribunal below, my lord, with my application.
No, you are coming here under 227. If the documents are not self-contained, how will I apply my mind?
Madam, I may submit this document, madam, at any time.
Okay.
Permission.
Okay. On the prayer made by Mr. P.K. Das, counsel for the petitioner, is permitted to annex left out documents by way of an additional affidavit. List after
After petition,
list as prayed for list after the ensuing winter vacation. 6. Time being. Okay, you tell the time, Pisa, otherwise Datta is also a busy man.
Can it be next Monday, man? Can it be next Monday?
Next Monday, yes. Okay.
11.
Oh, okay. The joint prayer made by learned counsel for both sides, based on next Monday.
Right.
7. Mr. Kalita, your matter. Please come for the first time. Come for the first time.
Yes.
You are appealing for the respondent.
Yes, sir. It will file an objection in this IOA.
What is your objection?
We file the IOA for
But once an appeal is admitted, we'll have to stay it. Otherwise, the appeal will become infructuous. You said decree for specific performance. Now, what happens if the decree is executed and we are hearing the appeal? What happens? What according to you will happen if the decree is executed and we are still hearing the appeal? According to you, what will happen? No prejudice. Very good. Please explain why after execution of decree, the appellant will not be prejudiced. Give me one reason You'll be prejudiced. Ah, yes. Ah, you're right. So we are staying it. You just record your presence. You have filed a caveat. Okay. Uh, what is the decree for? Decree for? What is the final order in the decree? Oh, plaintiff suit is dismissed. You are plaintiff.
Yes.
You are plaintiff. Oh, sorry. I misread it. No, it's okay. I'm admitting it. But there's no question of stay then. There's no question of stay.
Question of stay is not there, but
Huh.
I filed an application for injunction. Injunction during the pendency of the appeal matter, so that they cannot sell this. Because I have already paid a major amount.
No, but you see that prima facie, if your suit is dismissed, prima facie case for injunction will not be maintainable then. If your suit for specific performance is dismissed, then the prima facie case is no longer available.
It was for specific performance matter. I paid a major amount, as per
Yes.
the agreement matter. But they, during the pendency of the, before filing of the suit matter, they cancelled the agreement. So I have been compelled to file this suit. See, however, I filed an application for injunction so that they cannot sell or transfer the land to some other person during the pendency. That is my fear.
Where is your plaint? Where is the plaint, Mr. Kalita? Which page?
Fair person in justice case 54.
Mr. Kalita, there are 2 or 3 things I would not be able to follow in this matter. 1 or 2 things I have not been able to follow in this matter. Number one, as plaintiff, this uh, cancellation of the specific perform the agreement is not annexed. At page 107 in your cross examination, page 107,
Yes.
your cross examination, about 9 or 10 lines from above, you have made a mention that I have not challenged the cancellation of exhibit 1 in my suit. This is what you have said. Page 107. 9 or 10 lines. I have not challenged. Correct. Now this cancellation document is not even annexed by the defendant one in the evidence on affidavit.
Really, my lord, I issued a notice. What happened, my lord, in this case? They obtained the NOC with a different boundary. So I insisted that the boundary should be corrected or a new agreement should be entered in. But they refused. Instead of that, they cancelled the agreement. So I have been compelled to file.
No, where is that cancellation document itself is not proved by anyone.
They stated, my lord, they stated in their written statement.
So you have accepted that position.
If they can cancel the agreement and refund my amount, which I have paid as advance, that would have been a different thing. They have not offered. They have simply canceled. So I have been compelled to file this suit matter for specific performance. Either let them return the amount with interest, because it is this is of 2014. 2014, my lord. We have enjoyed, and our husband, my lord, the present respondent, husband entered into an agreement.
Okay. Can we come to page 55, Lordship? Their plain, Lordship. Page
50?
55. Page
Fine.
55, Lordship. The schedule in the plain, Lordship, and the schedule is in the agreement is different. Page 89, Lordship, the agreement. The schedule of the land.
Where is that agreement?
Agreement page 51, and the schedule is at page 55, Lordship. This is the plain, Lordship, and the agreement is, Lordship, at page 86, and the schedule is at page 89.
That is the problem, my lord.
And it has been discussed in page 54.
Page?
Discussed in page 54, Lordship. And
Lordship, you will please case 62, my lord. What NOC they have obtained. That is the boundary.
let our objection be filed, Lordship.
According to the schedule given in the NOC, we have filed this schedule of the plain land. It at page 55. We requested them either to execute the sale deed as per the agreement or to correct the agreement for sale. According to the NOC. They refused, ma'am. And immediately canceled the agreement. We also maybe please to see the agreement I would say next step. Agreement is at page 58, man. Would you please to see the boundary? Yeah. Page 61. And NOC at page 62.
Heard. Mr. P.K. Kalita, Senior Counsel, assisted by Ms. M. Kalita. N. Kalita. N. Okay. M. Kalita, Counsel for the N. Datta. Oh, I'm sorry. Ms. N. Datta, Counsel for the appellant, as well as Mr. K.
PK Basu.
P.K. Basu, Counsel for the respondent. By filing this appeal under section 96 CBC, the appellant has said the judgment and decree dated 25/8/2023 passed by the Learned Civil Judge number 1, Kamrup Metro. Civil Judge within bracket Senior Division, bracket was number 1, Kamrup Metro Guwahati in TS 410 of 2015, by which the suit for specific performance of contract was dismissed with cost. Appeal is admitted for hearing. Call for the reports. That a formal notice issued on respondent number 1 without requiring the appellant to take press steps, as the respondent has already entered appearance by filing caveat. List after 4 weeks awaiting receipt of LCR. In the injunction application, specific, plus specific relief acting. That's also for the applicant and opposite party. This is an application under Order 39, Rule 1 and 2, read with Section 151 CPC. By this application, the applicant, who is the applicant in the connected case, by corrected appeal, has prayed for ad interim injunction to restrain the opposite party to sell, alienate, or transfer the suit land in any manner. So, Kalita, I feel myself in a difficult situation. You see, since I'm not finding it, I'm asking you. In the trial court, you did not pray for an alternative remedy of a refund of your amount. Correct, that is not there. Even in this appeal, a prayer to that effect is not there.
I cannot send the prayer, my lord.
No, because under 21, that can be made at any time.
Parties, my lord, if they want to pay, refund the amount, my lord, that is different thing, my lord.
No, but you see, under Section 21, it says that it can be an alternative remedy. And there are other provisions in the specific relief act which says that if, even if that prayer for compensation is not made, under subsection 3 of, I think, 22, it says that the court can still permit you to amend the plaint. Even in the appellate court, you are not there. Okay. So I'm not being issuing a notice at this stage. Yeah. You should notice.
Actually, this is a case for proper compromise, my lord, because either they have to, if they want the money, my lord, if they are ready to sell, my lord, they change the boundary as per the.
No, that is the entire difficulty, because you see, they have admitted receipt of money, but no prayer was made. No alternative remedy was claimed when the matter was heard. So that's why I'm asking you that I'm finding it difficult. For the purpose of injunction, it's very difficult.
I pray, my lord, that they in the decision, because if they.
No, because you see, if you are claiming money, then it's an alternative remedy which may not entitle you to an injunction. That's why the difficulty. And this is the issue notice in this application. In the first time you add that. Issue notice on this application and the 39 that I didn't print. The objection, if any, to this interrogatory application shall be filed within, this is from Guwahati, shall be filed within 10 days from today. Notice, make the notice returnable after 10 days. Give a date after 10 days in this application.
Yeah.
Returnable 1812. An objection, if any, be filed is 1 day prior to the next date of listing. List this interlocutory application on 18/12/2023. Then there is a caveat discharge in a DK Basu. Caveat discharged. You file your objection within 10 days.
Okay.
And you take instructions of what Mr. Kalita is saying. Whether you are, whether the respondent is ready and willing to deposit the amount already received by them. That is something which is admitted. Take instructions on that, specific instructions. 9.
Item 9.
What are responding?
Claim application is dismissed.
Yeah.
Okay, none appears on call for the appellant. However, Mr. A.K. Dattar and CGC is present. Is admitted for hearing. Issue notice returnable in 4 weeks. Requisite extra copies of this memo of appeal. Oh no, this will be an appeal under appeal under section 23 of the Railway Claims Tribunal Act 1987. Again, judgment on August 1, so page 1. Appeal is admitted for hearing. Call for the records. Issue usual notices returnable in 4 weeks. Requisite extra copies of the application. This memo appeal be served on the learned CEC. For onward transmission to the respondent. Rest after 4 weeks. Copies, extra copies within 2 days.
Item 10.
For the day. Yes.
I am the plaintiff. My suit has been solved.
Suit has been.
But due to it is interim order, it has been stayed by
Or suit has been stayed. Then you address us and tell us why it should not be interfered with, why the stay should not be extended. Because you were allowed permission to amend the plaint.
Yes.
The plaint is cause of action in the plaint is 1998. Cause of action in the plaint is 1998.
Yes.
Correct. Now, if you are permitted to amend the plaint in 2023, whether cause of action which is barred by limitation will not come into foreplay.
My lord, the cause of action, my lord, it's of my lord 2012, my lord.
No, it is 20 June 1998. if the pleadings of the petitioner is correct.
My lord, may I come to paragraph 2 of my plain, page 14. Oh, my lord, may I come to paragraph 6, my lord, 6.
No, no, I don't know. You see, when I'm saying a particular date, you'll have to show us that it is not correct. I have you come to page 17.
20.
That is a copy of the plaint.
Yes, yes.
Para 11, cause of action arose on 26th, 1998.
The suit was inherited by the plaintiff. My lord, that is one cause of action.
No, I understand. It's a bundle of facts. I can't read everything separately. Now you are amending the plaint.
My lord, I am amending, my lord, not for this money. My lord, I am amending for paragraph 6, my lord. Paragraph
Page?
6, page 16. Page 16. Paragraph 6.
Page 16, yes.
Paragraph 6, that the right title and interest of the plaintiff and the performer defendants in respect of the suit claim has been clouded as a result of legal mutation, insertion of the names of the defendants, they are further in the record of rights without even having any document of title. The plaintiff and the performer defendant requested the defendants several times to vacate the suit claim and to hand over the class possession. But the defendant turned a deaf ear to the repeated request of the plaintiff and the performer defendants, and also refused to give due share of paddy crops till the year 2017. It may be, however, mentioned here that the plaintiff has no reason to pray now for recovery of class possession of the suit land. The plaintiff craves leave of the honorable court. This is important, to pray for eviction of the defendants, trying to defendants and or for delivery of recovery of class
Correct. Let
possession.
us stop here for the time being. You say that you say that they were cultivating the crops till 2017. The paragraph 6 you are reading,
Yes, yes,
and after
yes.
that they have stopped.
they stop,
Correct.
yes,
And they in this next line you write they have ceased to cultivate the land from 2018. Correct.
yes.
Now come to page 42. Now you are saying that by amending the plaint you want that they should give you mean profit of 2,50,000.
Yes,
So that means the mean profit would be from 2017 and before. Is absolutely barred by limitation.
from the year 2012 to 2022, for 10 years,
When they are not cultivating.
they were not cultivating.
I think I understand. You see, principle of Adhi would be what? Your first line is that they did not give us the share of the crop.
Yes,
Now, even if they can't cultivate, then also share of crop. It's something very strange. I don't find it anywhere. If you can show me the law, where even if there is no cultivation, there will be Adhi amounting to 2,50,000 per year.
so my lord, here, my lord, we have filed this suit, not
Very
only for
good.
this particular reason.
Very good. Where is the cause of action? Claiming 2,50,000 cause of action starts when? From 2012.
Yes,
And you still say it is within limitation.
from 2012, my lord, they were not cultivating.
Correct.
But now, my lord, when they filed the.
Correct.
yes,
So
my
under
lord,
Assam
have-
Urban Area Rent Control Act, Assam and Agriculture Area Tenancy Act, the cause of action to recover rent dates back to 2012. If it is filed today, and it is within limitation. That's your argument.
it was not, my lord. It was not
No, I don't know. You formulate your argument and place it before me. I said your cause of action is 2018. You said no. Then when I am showing you the cause of action that it is even prior to 2019, it is from 2017. Then you say that you are amending the plaint not for that relief. You are amending the plaint for seeking relief of recovery of money.
Lord,
And recovery of
we are-
money is 2012.
Earlier, I was filed this suit, my lord, for seeking, my lord, right title.
No, no,
insurance.
those I have, you see, when I can point out from one page and another page and give you the specific paragraphs, you must assume that I have read something. So don't go with what I have prayed for, what I have done so. You have asked for amendment of the plaint. Whether it is barred by limitation, that is the question I am asking you. So please restrict your argument to those facts only.
Lord, my respectful submission is that, my lord, cause of action is a bundle of facts.
Correct.
my
And it
lord,
can commence from 2012.
1998, my lord, one of the cause of action.
And it can commence from 2012, recovery of rent. That's what you are saying.
Yes, because my
Correct.
lord, now in the WS, my lord, they have said, my lord, they are cultivating. That's why, my lord, I have.
No,
made
no,
the
no,
prayer.
no. Recovery of rent is permissible beyond 3 years. That is your argument. Correct. Now let me deal with it. Speak loudly. I am allowing your petition. You are agree by that? No.
My lord, may I place it, my lord?
Yes, no, now you do it.
Hello?
Please present.
Yes.
Hmm.
My lord, my father, my lord, late Kalisharan Burua, my lord, he died on 20/06/1998. And my lord, the defendants, my lord, hearing from his, my lord, they have been working.
Oh, I am not
earlier.
adjudicating an appeal from the first appeal in a suit. Correct. So who was the father, who was the grandfather is not material.
CRP IO.
Correct. But I am not deciding right title interest.
Yes, yes, yes.
So who is the plaintiff, who is the father of the plaintiff, who is the grandfather of the plaintiff is not material.
That is,
The question is that the application for amendment was allowed.
yes.
And the presentation is that it introduces cause of action which is beyond limitation. So if the amendment is allowed in your petition of 2022, the cause of action is on the date when the application is allowed and amended plaint comes into record. So anything beyond 3 years, why it will not be barred by limitation? That is the question I'm asking. And this is for the third time asking that question.
Lord, that event, my lord, lord, actually, my lord, I am not anticipating that. My lord,
You
my
have
lord,
opposed the, you see, she's a young girl, you have opposed a prayer for adjournment. Now that means you are ready for argument.
I am not saying.
No, please don't say everything. I am very good in telling stories. Every day in my courtroom, you will find me telling stories. Story is something which comes naturally. I am a storyteller. So don't tell those things. A young girl was making a prayer for adjournment for today. You oppose the prayer. So now we are hearing you.
Lord, you know that your lordship will find. My lord, to that respect, my lord, what your lordship has made an query. To that respect, my lord, let me have some homework, my lord, on that particular point.
No. You see, when you are opposing the prayer, that means you have done the homework. You are ready for hearing.
My lord, then I may be allowed to place.
Yes, great. We'll take it up at 2 o'clock. You do your homework by then. At 2, yes. You wanted time for homework, we are giving you that also.
Yes.
We don't want a lawyer going out with a grievance that I have not been heard.
Yes, sir.
Be there at 2.
Yes.
And read it and come. This time I will not be reading for you. Till 2 o'clock you have time, read it thoroughly and come. Correct? You will have to address.
Yes.
Item 11.
You are praying for an adjournment?
I paid for an item.
Yes. Okay. Both sides are represented. On the prayer made by Land Council for the petitioner, the matter stands adjourned today. List on.
Sixth of December. Sixth.
No, not 6th. It will go to the week commencing 11th. We'll take it up on 13th. 13, 12.
Or black.
You have the records with you? You have the records with you? Then how do you oppose the prayer?
charges already framed lordship. And today is the date fixed for evidence lordship.
How many witnesses have been examined?
Lordship, today is the first day lordship.
This charge sheet was submitted when?
On 27/9/2023.
21,
23.
23.
Complaint has been filed 14/6/2023.
Okay, okay. Okay. Have the updated instructions by then? Okay. Item 13.
Please, your lordship.
Yes.
Senior counsel, Mr. Escom is pending some other proof. Faster into the time.
The senior counsel, I did not know that. You're senior, okay. Okay. After some time. Okay. We tell him the time so that he can also come. Mr. Shom, tell him the time.
For the.
Hmm.
Probably. I don't counting.
Okay. List. Okay, list after a week as preferred by Mr. J. Kalpa, counsel for the petitioner. Sorry, appellant. Okay.
Okay.
Fifteen.
Item 15.
There's no representation of the appellant or hence exercise the matter stands adjourned today. List after a week.
Item 15.
Yes.
Yes, my name is not shown. That's number one.
Pardon me?
My name is not shown.
Maybe it's not known.
Yes. Possibly it is settled. It is settled.
Possibility is settled.
Yeah, because I consulted to do this because some cases directly listed in the local catalog of 9. Since my name is not shown.
Okay. Okay, next week, let him have this.
Yeah, maybe Friday.
Oh, okay.
Friday for I'll give the
Okay.
showing my name.
Okay. Mr. R. Sharma for the learning counsel for the appellant and Mr. Your Vakaratma is there on record.
Yes, my lord. I want to file my also. It's a earlier and just advocate for Restaurant number 1. Funny. Possibly Abraham. Possibly I might.
It's not forgotten even.
I have a copy of this.
Let's show it because
And today I have got because my name is not on that.
no, that's okay, but your Vakaratma is not there. In the section 5 application, B.K. Purkayastha is for respondent number 1.
He left his, because his empanelment.
Huh.
Subsequently, I was deputed.
No, Mr. Paul, we don't have your presence recorded here. You don't have it.
Sometime my lord, Vakaratma is not in the record. I have seen and not the case.
No, but you see, I can't give a direction for recording your name in the registry.
Yes. And
We'll ask the registry to examine.
I think on Friday. this Friday or day after tomorrow,
Oh, okay, Friday, just,
because it is already settled.
no, it's okay. Only the problem is that if I dial the registry to record your name, it must be some document must be here.
Yes, fine.
So that's the problem on the council, the learned council has submitted that he has entered appearance for respondent number 1.
Yes.
By filing a wakalatnama, which is not found on record. So accordingly, the learned council shall inform the registry about the filing receipt number in respect of his wakalatnama. To stop, in the event the wakalatnama is the fresh wakalatnama is found on record, the registry shall reflect the name of the learned council filing the fresh wakalatnama as counsel for respondent number 1 in the cause list by listing the matter next. It appears from the office note in IS Civil 2794 of uh, 2018 that 3 learned lawyers have entered appearance for respondent numbers 2 and 3. So their names are not reflected in the cause list. So accordingly, the registry shall examine the first order sheet of IA 2794 of 2018 and reflect the name of the learned counsel appearing for respondent numbers 2 and 3 in the cause list by listing the matter next.
We have to.
Based on Friday.
Right, 8th of April.
Okay.
Myself.
17.
Yes, 17.
Lordship, in this matter, would file our executive and reply against executive within a day or two.
Just a minute. This IA is for
Your lordship, the matter is of
in,
2015.
in condonation application, you want to file affidavit in reply.
Yes, sir.
Why?
Lordship, they have filed their executive in opposition.
I understand. You see, it's a delay of 66 days. If you have 60 days, right?
Yes, sir. Yes, sir.
So 66 days delay, if you have explained and he has countered it. If you want to file an affidavit in reply, the first impression is that you have a bad case.
Your lordship, indeed, they have a bad case.
So that is the impression we are having. In a condonation application, if you have to file a reply, it means that you would have a very bad case in the application. What is the point you want to controvert? Let me understand it.
If they don't have any problem.
Huh?
If they don't have any problem. we can-
No, it's not a question of their problem. Mr. Hussain may have 101 problem with your application. But I want to ask from you, what is one problem for which you want to file a counter to an condonation application for delays 66 days? You see, this is a 2020 application. We are now in end of 2023. Because if you want a delay, you can't help it. For 66 days delay, this is the 3rd year. That means 1000 days have already gone. For condonation of 66 days of delay, and you still need an adjournment. Doesn't serve the interest of the petitioner. And who takes care of Mr. Hussain? If he is appearing for 3 years, he would be appearing pro bono.
Lordship, they have fulfilled the plan.
Yes, Mr. Hussain, we adjourn it, we can't help it. If the petitioner wants an adjournment, we
Lordship,
record your submission.
Your Lordship, the thing is that the IA was filed in 2020, but they are challenging an order of 2014. So they filed an MSc appeal, they kept it pending for 5 years, and after 5 years, they have filed an interlocutory application for delay. So your Lordship, technically, your Lordship, though they are saying that the delay is of 65, 66 days, but they had kept us waiting for 5 years, then they have filed an IA.
Okay, I'll record that statement. I'll record that. Miss Inanda, Yunanda, counsel for the applicant prays for an adjournment. So Mr. I. Hussain, and counsel for the respondent number
Lordship, I'm appearing for respondent number 2 to 3 and 5 from 5 to
2 to 3 and 5 to 8.
11.
5 to 11 opposes the prayer for adjournment on the ground that although in this interlocutory application, which was filed in the year 2020, the applicant is seeking condonation of delay of 66 days, but in fact, but he submits that the connected appeal that in the connected appeal, the MSCT award of 2014 has been assailed. First off, it is submitted that the appeal was kept defective for 6 years, and thereafter this interlocutory application was filed. And accordingly, it is submitted that the explanation of delay only in respect of 60 days, 66 days would not be admissible. First off, they said submission is noted. Next, on the prayer made by learned counsel for the applicant. The matter stands adjourned today as a last charge. It is made clear that on behalf of the applicant, no further prayer for adjournment shall be entertained on on any ground whatsoever. List after. Now tell us 1 year, 2 year, 3 year. Next week, any date. 15/12/2023.
Like,
This case is already settled here.
Already settled
I think so, 9th of. For Lokadam.
in local. Okay. So RC Paul, counsel for the appellant, and Mr. A. Bhattacharya, counsel for the respondent number 1 are present. And he submitted that pursuant to a pre-settlement meeting, the matter has been referred for listing before the National Lok Adalat on 9/11/2023.
9/12. 9/12.
9/12. Oh, I'm sorry, 9/12/2023. So accordingly, matter stands adjourned today. List in the list of 15/11,
No, no,
15/12.
Already settled. It has been settled, but it has come to the list in the Lokadam. That is I mentioned.
No. After Lok Adalat, it has to come to court and then it will be closed. Not required, because it will be closed there. Yes, sir. Let's say it will be the National Lok Adalat. So accordingly, matter adjourns sine die with liberty to the learned counsel for the parties to make a mention if the settlement is not recorded in the National Lok Adalat. Yes, yes.
To review some original documents before family court. After issuing notice and appearance of the parties, the matter was taken up.
These are both learned counsel of this court. Can we take up this matter in the chambers?
Yes, today, she has suggested for today. So may I pray that let the matter be come up on Friday in the chamber.
No, this is a matter we will take up in chambers.
Chamber, Friday.
Today also,
Today, my lord, I have some personal problem. My car, my lord, met an accident. So I will have to go to what is
okay, you have this Tesla. No, you said your car met with an accident. That
Yes.
means your car is self-driving car.
No, not driver. Driver was there, my
Oh,
lord.
driver was there. Okay. 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 No, let it come on Monday. Let it come on Monday. Next Monday. No, you are in person.
Yeah, in person.
No, you don't have a counsel.
I am represented by. He is represented by me.
So therefore, we just have to have it Monday or difficult days.
Wednesday, Lord.
Then Wednesday, third. No, not this week. This week I will not be there. 13, 12, 20. So not 13. They're making it on 15, 12.
Yes.
15, 12. You say both sides are represented. You are praying for adjournment today? No. It is noticed that both the parties are under counsel practicing in this court. So therefore, the court intends to examine both the parties in chambers. To stop accordingly, as agreed to by both sides, this is the matter on 15/12/2023. To stop, both sides are put to notice that on the said date, the matter would be taken up in chambers. For examining the parties. So accordingly, both the petitioner as the respondent shall be personally present on the said date.
Along with the advocate, madam. Along with the counsel.
The council may not entertain when we are examining the parties.
As
So, because let me make an entry here.
Initially, my lord, both the advocates are heard. And thereafter, my lord, parties were heard personally.
No, that's okay, but Mr. Pukasta,
Well, as well.
let me,
No, today I have some problem. Why don't you understand? Please understand, I have some problem. No, they have.
his car has met with an accident.
I am not mentally in a position.
Okay. Okay. And this item, this tag matter, same thing, 19 and 20 both. Are separate orders, huh? Okay.
Obliged.
I think 21.
Yes.
It is for restoration of a matter, appeal matter. And I am the newly engaged counsel matter. I did matter listening for non-proceeding. There is private parties to the office of the matter. So what are it? Page 9.
Yes, what is the explanation?
My lord, the petitioner, my lord, my lord, applicant has do not have the knowledge, my lord, that her case of listening for the my lord, she was there, my lord, our council earlier and just to not communicate with our madam. But in spite of when she has better communicated, she has not acknowledged, she has not replied. And she has personally might have come to the court and might have investigated on her own case. And then only might have she has come to the knowledge of the case of important person. If I were might have for consideration of delay, that we were when there is no actually follow on part in the petition. During the use of the same well, another significant fact, your logic from me, I will draw you that time is in.
Okay, so Mr. DK may be counsel for the applicant. You should notice on this application, returnable. Give a date in January. Returnable on so and so.
Eight one.
The petitioner shall take steps within 5/12/2023 for service of notice on the opposite party. Next one, list on so and so. Motion and notice. Take a short break and come back. Both sides are duly presented. The case is ready at Zika service and the LCR is also received. So accordingly, list the matter for hearing in the month of January 2024.
Problem.
23.
This case also my lord already settled. I keep on nine.
Okay. Same order
Same.
as earlier. Matter settled on pre-settlement negotiation.
Keep on nine.
What?
Much.
Let's remind the local authority. Mr. R.C. Paul for the appellant and Ms. P. Bhattacharya for the counsel for respondent number
1A and
1A and B. Okay. 24. Yes.
This was true. Taken step to register. This one dated was to 1/12/23.
Okay, you have not filed the say. You have taken steps. Okay. On the prayer made by A. Ahmed,
On behalf of
Mr. Ayu Ahmed, counsel for the applicant, sorry, petitioner. Matter stands adjourned to enable him to file affidavit of service of notice on the respondent. List after 2 weeks. Okay. Make a mention if it is not listed. After 2 weeks is again another vacation coming. Be very difficult to manage. But yes, 25.
Can be taken up next week.
No, just what is this IA for?
I have just misplaced my brief and that's why next week.
For readmission is there's a delay of how many days in approaching the court? You're not aware. Okay. How many days delay? Are you aware? Anybody have seen that? There's no delay. So we condone this, what you call, we allow this application for readmission. Any objection that,
We have filed objection.
what is your ground?
The
the current application, they have taken a ground, actually the name has not shown in the policy.
Okay.
And there is a mistake in the spelling. But we have submitted the opposition that actually the case was admitted in 2014, your lordship, and it had the same name was shown. And then in 2022, it was dismissed because of non-contribution.
No, what is the error in name? Let us see what is the error in name. What is the error in the cost item?
My name
It's okay.
my name was wrongly indicated, that's why I missed the case in the cost.
No, what is the wrong spelling?
I write my SH double E L A. Here it was reflected as SH I L A. So therefore I missed the case my lord and the cost. That is the ground, my lord.
Okay, that is the only ground.
Yes, that is the only ground.
Anything else?
We have submitted that in 2014 itself, that name was showing, and subsequently there are many hearings. So the petitioner has not taken any steps earlier, and there was negligence on this part. And even in the Wakalatnama, it is shown the signature is the same name is showing in the in the order, your lordship. We have annexed the copy of Wakalatnama also in our option.
Okay. Wow. The order will be in IA Civil 950 of 2023. By this application under Section 5 of the Limitation Act, the applicant has paid for condonation of delay of 114 days beyond the period of limitation in filing the. Oh, this is substitution. No, not substitution.
Which case 24.
This case 24. Her Mr. Sheila Dithil and counsel for the applicant. And Mr. J. Das and counsel for the opposite party number
That's for 2B.
2B. And Mr. M. Das, counsel for opposite party number 1A to 1B. 1D. Okay. And who appears for other? Substitute here, C and D. You are appearing for 2AB.
2B, your lordship.
2B. Who appears for A, C and D? No one. Who is the counsel for other respondent number 2, A, B, C?
Mr. R. Sharma is there.
R.
R. Sharma is there.
Rajiv Sharma.
His name shown here? No. You see, Ms. Sheila Dithil, It appears that in this court, I am only interested to know who has entered appearance, who is not. Nobody assists the court to tell us as to who are the parties, whether notice has been served. Restoration application, we have not served copies to others. It seems that only I am interested to look into the office notes, the order sheets, and then come at a finding.
Sorry, madam. because I have
No, you can go through the records. At least service should be complete. That much, that I am entitled to know that.
served them notice, both of them, and they have filed their objection.
But their names are not reflected in the cost title, in the cost list. You should have told the court that that should have been the first thing, that the other side is not represented. You see, you have filed an application on a premise that your name was wrongly spelled. Is it not required that the other side be heard when you have served notice on others and their name is not reflected in the cause list? You are doing the same thing. You are aggrieved only by the incorrect name, and you are not pointing out before the court that there are other lawyers for the other respondents, as if I am the only having the duty of wasting the court's time, finding out who is appearing, who is not appearing, who is for A, who is for B, who is for C. It is only the duty of the court. Others are very, very conveniently, what you call, complacent, so far as looking at the order sheet is concerned, to assist the court.
I'm sorry, my doctor. I will inform the.
No, inform, but you see, they are not here. You should have told us that the other side is there, his name is not reflected. You see, you are aggrieved, Mr. Shila, this is the only ground where you dismiss it.
I'm sorry.
No, it's not a question of being sorry. You see, I'm wasting time. I've till now I've read 7 or 8 IAs to find out which is the application. Then you tell us it is 24. When I read 24, I find that there are other names also. And in other names, there are other counsel. You don't point out that also at that point of time. I have to ask, and then only you give an information. It amounts to misleading the court. I would have allowed this application. You know why I'm reading this. Because I intend to allow the application. I ask questions. And at that time, I find out there are other lawyers whose names are there, and you are not telling us to the court. So why we should, merely because of this spelling mistake, why we should not dismiss your application? There is no other Shiladitya, Shiladitya, there's no lawyer named Shiladitya in the court.
Because I have served by the name, by the alphabet.
No, that's okay.
Therefore, I have made it possible.
No, that's okay. But you see, when you are preventing the court from knowing who are the lawyers who are in the matter, why that cannot be a ground to dismiss your application? Don't do it. I would not expect it from a lawyer not to assist the court by looking at the cause list, whose names are there, whose names are not there.
It's my mistake, madam. I apologize.
No. And I'm wasting the time. 12:05 I came. 12:07 I came. 12:07, now it is 12:30. Just because you are not assisting the court, not telling us that who are the lawyers on record. It's unexpected. No, not expected. Not unexpected. I should have expected it, but it was not expected, at least from you. I go by the principle. Don't forget the sin, don't forget the sinner. If you don't what you call, assist the court, I'm not so easily forgetting anything. I told you the principle is that forgive the sin. Don't forgive the sinner. Don't forget the sinner. That is something I not forget very easily when you don't assist the court. If you don't have time to look at the court records, you see, I'm wasting again 31 minutes, 24 minutes I'm wasting of the court on the prayer made by learned counsel for the applicant. The matter is adjourned today, as is not ready with the brief list after 2 weeks.
Sorry, madam.
No, don't be sorry. This is something I'm not accepting. This apology is something I'm not accepting. To the other learned counsel also, if there is anything to be seen in the order sheet, please see it and assist me. Because if I have to go through this order sheet, note sheet, find out for myself, I'll be what you call, I'll be expressing my annoyance in the order sheet. Item 26.
Yeah, official says I am not telling justice serving, but it is available in I number discussion 413.
413.
Ten two, I could not taken justice serving because already expired. And substance it is identified.
No. What is this application 413
One female was actually
for correction, rectification of the cost title?
that,
Correct.
because there, the person, the dead person has been complete. Actually, his legal years is to be served.
Okay, in 413 you are appealing?
One to
One to
nine,
nine.
I'm hearing. 1 to 9, madam.
Yeah, appealing to for 1 to 9.
1 to 9. In the RSML, I find my wakala. 64.
But still this can't proceed, Mr. Ahmed. 413 is for correction.
There are three petitions, one condemnation, one abstention, and one putting of the abatement. So we also file three petitions for correction.
No, this is something we can't accept. This limitation application is 1279. Where is the notice
No,
issued on?
It is regarding, respondent number 10-2. Respondent 10-2 expired
Yes,
and subsequent has been, filed for respondent 10-2. His legal has to be implemented.
yes.
The person can be the IA number, 1279.
No. You see, you are missing it. This is not the point which I am trying to tell you. Mr. Ahmed. Uh, uh, are you sure that what you are submitting is correct state of affairs?
Under the,
I'm asking you for some reason.
actually,
Please think over and then address the court. The submission you are making, is it correct?
under the. May I read the note, no?
Yes. No. First of all, I'm not asking you to make submission. What I'm trying to tell you is that please think over and please tell me the submission which you had made, is it correct? After that, you make your own statement. Question is, the statement you have made, is it correct?
Actually, earlier I am not in the case. Subsequently, in the event, I.
No, whatever be, but you have made a submission. I'm just asking you, the submission you have made, is it correct?
Because, that's number 10 expired.
No, I'm not on those things. My only question is, you made a certain statement. Can you say with conviction that you are correct?
As per information, I am correct. As per information furnished by the client, I am correct.
Then what I will do is that if this be so, then there will be a consequential order in the main case. You see what has happened. Your Dasti service affidavit is filed on 20 February 2023. Please write the date. It is important. Write the date. Correct. You know that. Okay. And this application, which is IS Civil 1279 under section 5 of the condonation application, was filed in May 2023, 11 May 2023. So the service made earlier.
Yes, in justice service, I mentioned in my.
No, that's okay. But here notice have not even been issued. How can that justice service in an earlier application be taken cognizance of in this case?
This case, what are the member, this court permitted me to take justice service in 2018.
No, you see, in a suit, there may be 100 of miss cases. Let us say Mr. Ahmed is happy in filing miss cases. You file in a particular application, 100 miss cases. So notice served in one application, is it good notice on the other? Condonation application can't be allowed without service of notice on the party. You see, condonation application is a substantive right. Unless you take steps there, mere steps in another miss case.
1647.
No, application 1279. No, whatever we take steps, all this be served. The service made in another miss case, I will not accept it for service in a condonation application.
Here, my lord.
Unconnected service. You see, service in a main case would be good service for a miss case. But I have not come across, unless you show me the law, that a service in a miss case not being section 5 application would be good for substitution condonation application.
Hello, the kindly take up IA number 1647.
1647.
Is the.
One 164715. Yes.
the main subdivision petition.
Yes,
But here, well, notice has been issued, my lord, then office note reflects that, just cover.
1647, no notice was issued here.
1645 is condemned. In that petition, filed with condemnation.
1645. 1645 is condemnation application. Yes, okay.
Here notice was issued, and, after written service of the notice, it has come to learn that the rational term expired, and thereafter, successor petition has been filed.
Yes,
This was the rational number 10. And rational, really here the rational terms are, subdivision petition is 1647. It's the subsidy. Here, the commissioner reflects in condemnation petition, that rational number 10 who are made party,
what is that IA?
Abdul Sabbar,
What is that condemnation application? What is that IA?
condemnation application 1645, 2015.
1645.
Just filed earlier, my lord.
Yes, 1645.
You'll also can see paragraph 3, 4.
Yes,
Then you also kindly see the I number 1647.
no,
notice
what
for
about 1645? What has happened here?
Here, notice
1645 notice issued. Yes. Then,
this petition filed because of there is a delay in filing the substitution petition. And substitution petition is 1647, 2015.
one six four seven, okay,
And here you also can see paragraph 3.
1647.
Paragraph 3, my lord.
Yes,
We were legal here. That's number 10.
yes,
Then, when notice go, my lord, then we come to the, it is ability informed me that the Abdul Sabur is already expired 18/12/2020 before filing of the case. And he has been made such a party in this petition. That is why I filed a petition. I have 413 for correction because that person already expired before filing of the case. And is legal here, rational number 10 to 1 and 2. We can substitute. Then we file a petition, correction petition. Thereafter, when notice gone, we again come to learn that 10.
no, this affidavit was filed in which case? Your affidavit of Dasti service in which matter?
It is
That you have filed in 413.
41 and 415.
Hmm?
413, 417 substitution. But 1647 is the substitution petition.
Still, it takes me back to square one. You see, notice in this 1279, 1279 you say is Section 5 Limitation Act. This notice which is appended in this IA 413 is a notice issued in 1645. Correct. 645. In 1645, when was the notice issued? Twenty-two. You see, here steps was never taken. In 1645, steps was not taken in 2023. Your affidavit of service is in 413. So does the notice serve on 413? How can I accept it for other matters?
Also kindly see the order. It is 7/2/2020.
In which case?
RS 64 of 74 of RS.
Order dated?
7/2/2020.
Yes.
Here I may be, by this order, I may be permitted to take justice.
Correct.
That is all. And there's I 4/1/2018. Due to some mistake or communication, I could not take justice in time. Thereafter, we take justice.
Same thing. You read the judgment of the Supreme Court of India in the case of what you call citation, I will not be able to give. It is LML that vehicle, LM Lohia, the LML scooters or something, LML scooters. It's something in 2018, 17-18, that judgment, LML scooters. You see, if we go by this, order of 7/2/2020 passed in RSA 64 of 15, along with other IAs. The next date fixed in the matter was 28/2/2020. So therefore, notice was to be returned on 28/2/2020. This notice was issued on 5/12/2022. 5/12/2022. And this affidavit is filed in on 20 February 2023. So the affidavit is filed beyond the period of service, beyond the issuance of notice, beyond the date of service.
Also kindly see my IA
No, I have seen it. I don't. I am running out of patience.
1/2/79.
Hmm?
IA 1/2/79.
1279. Yes.
Paragraph
No, no,
20.
no. You see, after every question, you are taking me to different IA. You see, is a service of notice beyond the period of beyond the date of service is a good service? Supposing you, Mr. J. Ahmed, gets a notice to appear in a court. Today you are served a notice to appear in court on 1/12/2023. According to you, is it a good service?
But my lord, apart from justice service.
No, that we don't know.
Usual process.
Either you take it within the time allowed by the court, or you don't do it at all. The court never permitted you to issue a notice beyond the period of beyond the service period. you take a step on 2022. The question is, were you permitted to take steps in 2022 December? And the date fixed. When you, by the time you have filed the Dasti service, you don't even say in this notice, service of notice, the date. In one case I have seen, I don't know about in page 10 of this application, you say notice is served on Mujibur Rahman, Abdul Latif, but some Ali, I can't read. So these three, it is served. Date of service is not there. Page 10 of your application, this Dasti service affidavit. Because only in the affidavit you say it was served on 25/12. So notice on 25/12 in when you are filing an affidavit in 413, can't be accepted service in other applications. So in all other applications, pending application, you serve notice. Because Mr. Ahmed, we won't have that much of time. You have about 6-7 IAs. We won't have time to go through it. Otherwise, you take a call, you can sit down, make a list of what has happened, and then tell us. Either you take fresh service or you tell us what has happened. Because I am running out of patience reading all these 7 or 6 IAs, finding out whom it is served. Because I'll tell you, I've asked you one question, whether the statement made by you is correct. Take it, because otherwise it will be very, very difficult in all pending IAs. No. Or whatever applications are there, condonation applications are there. You have to take service there. Condonation application and what you call this, because substitution application will come only after the notice on the condonation application. In this condonation application, you take fresh steps. All the applications. There are two condonation applications. Which are those?
The earlier one is my lord, 1645 public 2015.
1645 and
1279.
1279. That's separate orders. These are condonation application for condonation of delay. The affidavit of service, Dasti service, filed on 2023 in IA Civil 413 of 2018 cannot be accepted as good service on the concerned opposite parties. So it is submitted that the order to take Dasti service was made on 7/2/2020 in RSA 64 of 2015 and connected IAs. So according to the applicant is directed to take fresh steps for service of notice on the concerned opposite parties by registered post with AD. In addition, notice be served on the said concerned opposite parties by way of Dasti service by routing the process through the registry of the court. First of all, the date of appearance in the notice be shown as give a date after 5-6 weeks. Shown on so and so. First of the service is required to be effected on the concerned opposite parties before the said date of appearance. And an affidavit of service shall be filed prior to the next date of listing. Next para list on 18/1/2023.
Justice service sometimes we have implementation and difficulties. They are not very, but however, some person they.
No, if you don't want to take, I'm not compelling it to you, but you will have to take first steps.
Let it there, I will try.
Huh.
Okay.
No, if you have doubt, then you sub by registered post.
And
And
IA.
by usual post, not justice service.
We will file it. IA 4130 2018, I will put it.
4-1,
Correction.
Huh.
I will put it.
you will,
Correct, sister, I will send it.
okay, in 413 also, press it, separate order, 413. Then you say,
My friend.
then in RSA 64 of 2015,
129.
Huh?
Respond number 129.
Acha, Mr. M. Chaudhary, the council appeals for respondent was 1 to 9. In RSA 64 of 2015, another connected IAs pass a common order, say that in view of order passed in IAS so and so, these 3 cases, this matter are adjourned today. The same will be taken up on the next date of listing. Okay. Yes, both are done. Thus is revoked. Order of thus we are withdrawing. This usual process and registered post. Okay.
Hello.
Same. Okay. Okay. $27. Yes.
Lordship, this IA is for condonation of delay of 62 days.
Condonation of delay. Mr. D. Sharma for the DK Sharma. Okay. But then, Mr. Sharma, you'll have to pay your clerk well. Appropriate clerkage has to be paid to your clerk because your clerk has written D. Sharma. Correct. So if he records your name incorrectly, that means he is not happy with you. DK Sharma for the petitioner. Section 5 Limitation Act, 62 days beyond the period of limitation in filing the connected first appeal. Notice steps within 2 days, returnable on. Give a fixed date of appearance in IAS based on so and so. Awaiting service. 6 weeks, do you have that? 6 weeks, same 18-1. 18-1. 28. Is it within time? When did the person die?
Person died on 19/1/2023. Filed his application on 19/4.
19/4/23. Yes. Give it a copy. We'll take it up next week then. Miss
F.N. Jamal.
F.N. Zaman, counsel for the applicant, shall provide a copy of this interlocutory application. To Mr. T. U. Laskar, counsel for the respondent number 1. Who are the other opposite parties? Notice has been issued? No. Okay, case is ready, okay. As per order dated 2/12/2019, the case is ready as regards service on the other respondents. Number 2 to 14. Don't write that. It's already there. Don't write that. Okay. List and list after a week. Just a moment. Just a moment. Just wait. Okay. Resume 2.
Slide.
May I please your lordship? Lordship, in item number 24, lordship, already passed order. Lordship. One thing, lordship. Kindly, lordship, delay me with one thing.
Item
24, already ordered.
24. I don't know what has happened because I have signed all the absolutely no pending order today. Just 24. The interim order to be extended. Okay.
Highly obliged.
Okay. Maybe perhaps 1 or 2. I don't know. Most of the orders I have signed and they are being now uploaded.
Item 10.
Yes. Yes, first you'll have to tell us something. You'll have to address us and tell us something. Then we'll proceed to hear the respondent.
Can you adjourn for the day?
You want an adjournment still? I told you to be prepared. You see, it's not always that young lawyers get an opportunity of hearing. Correct. Number 1. Number 2, you read the mind of the court. But you are still not prepared. So then we'll adjourn it. Because we'll need something from you. For starting, the court is not the prosecutor. Correct. So at least some assistance will be required from you. And you read the mind of the court, that the court is going to allow your application. Still, you are not prepared to address the court on anything. Not always you get an opportunity. Correct. Okay. Both sides are represented on the prayer made by learned counsel for the petition of the matter stands adjourned today. List after a week. You get a lifeline.
Obliged.
Item 13.
I was not there. This second appeal, my lord, against the order judgment passed by the trial court and the first appeal on the ground that I could not prove that I am Mohendra Rathi.
Mohendranath.
So on that ground, both the court below had rejected the claim filed by the plaintiff, and I was the plaintiff for the London court. I have formulated some potential question of law. First, my lord, is that the trial court had relied upon an inquiry report of the circle officer It was never a part of the exhibition. At page 77, man. He tried to-
Just now. Because when I was trying to read it, this what do you call this? PW1,
PW1 is at page,
page 28. The cross examination I'm not finding.
no, it's there later on, but cross
Okay.
examination starts from page 45. First, the evidence was given, then the cross examination.
Acha, okay.
All of them have said that Mohendra Nath is also known as Bipin Nath. All of the witnesses of the plaintiff have said that Mohendra Nath is also known as Bipin Nath. And moreover, in the cross-examination of the DW, he has also says, in his cross-examination have said that the plaintiff is also known as Bipin Chandra Nath. That means he has another name, Mohendra Nath. At page 65. This is the cross-examination of the
55,
65.
65. Okay.
This is the cross-examination of the defendant witness. They had only one witness, we had 5 witnesses.
65, yes.
At fourth line, the plaintiff is also known as Bipin Chandra Nath. That means he has another name, that is Mohendra Nath. And also my petitions, my witnesses have said that he is also known as Bipin Chandra Nath, but he is known in the village as Mohendra Nath. On that count, and the learned court below relied upon an inquiry report which was never part of the exhibit, and the appellate court at page 102 at para 28 has had held that accordingly, even if the police report and report of circle officer Amguri, which were not exhibited by the defendant respondent side, are not considered. So that was never part of the record. And without
102.
102, page para 28. The report was never part of the case record. So how can they lose it past the order by judgment?
Where is the reliance on the said report?
Reliance at page 77. At para 23. That being the proposition, it is admitted here that an inquiry was conducted to trace out the identity.
77,
Page 20, para 23.
23.
So never part of the exhibit, but the appellate court has held it.
But otherwise also it has to come next week. You'll have to amend your this memo of appeal. You read 41, order 41 rule 2. You got it? No,
Yes, sir, I got. The substantial question of.
it's not set forth in your memo of appeal.
I have said it, my lord, ground C1, for that there is substantial question of law which arises for determination as to the learned court could have relied upon the inquiry report of the circle officer and the report submitted by the officer in charge Gauri Sagar police station when the same may not exhibited in the trial court by the. Number C.
No. You come to section 100, subsection 3.
In an appeal under this section, the memorandum of appeal shall precisely state the substantial question of law involved in the appeal. Otherwise, I will reformulate that.
You formulate that. That's why I say you have to amend it. And Mr. Mr. S. Counsel for the appellant, as well as Mr. A.R. Shom, counsel for the respondent. Next para. On the prayer made by learned counsel for the appellant, he is permitted to incorporate the substantial question of law in the memo of appeal in terms of subsection 3 of section 100 CPC. Lists the matter again for hearing under order 43 rule Uh, for hearing under order 41 to 11 CPC. Immediately thereafter. Most of the necessary correction is permitted to be done in the concerned section. Now you don't need to go there. In this section, you can do it. We'll send it today, we can do it tomorrow. It can be listed thereafter.
Immediately after the correction.
We'll send it today. Tomorrow you can do the correction and the day after tomorrow it can be listed again. Yes. Mm-hmm. 29.
Item 29.
May I say, dear Lordship, I have filed one CRP case against the order dated 36/2020 in Wednesday case 29 of 22 and in title case number 30 of 2020. Reversing and rejecting the amendment pledge. And I have filed one IA 3171 of 2020,
This is for condonation of delay.
condonation of delay of 8 days.
Okay, we'll have to issue notice then in this application. Okay. Ms. Ambatasarji, counsel for the applicant. Next para. So by this application under section 5 of the Limitation Act, the applicant has prayed for continuing the delay of 8 days beyond the period of limitation in filing the connected application. Issue notice returnable on 18/1/2024. So the applicant shall take steps within applicant shall take steps within 2 days for service of notice on the respondent by registered post with AD. You can serve it by email also. You can serve by email. So in addition, notice is also permitted to be served on the respondent by email. And on such service, an affidavit of service shall be filed prior to the next date of the same. Email or WhatsApp. Proof of service, no filing, so and so. Based on 18/1/2024. Item 30. Please speak loudly, I am not hearing you.
File an application for permission clearly with the folks pending on the suit line.
Lordship, we have not received any copy of the IA, Lordship.
Ms. R. Devi, and counsel for the opposite party, submits that the copy of the application has not been served on her. So accordingly, Mr. J. Laskar, counsel for the applicant, shall serve a copy of this application to the learned counsel for the opposite party. List after a week. Give it on Monday. Monday.
Monday next.
Monday. 31.
Item 31.
No representation from the applicant for High Justice matters stands adjourned today. List after a week. 32. Yes, Mr. Rashid.
Still, I have filed IXL, I have only not been prepared to listen, but I am not been prepared for 2 days.
111 days.
And actually, it is now also so that may not be required. And
We'll issue notice then.
yes,
Pardon me?
still, I may be able to withdraw the IL, delay petition may not be required.
May not be required. Okay. IA. Now, the prayer made by Mr. A. Rashid, counsel for the applicant, is permitted to withdraw this application. So accordingly, interrogatory application stands dismissed on withdrawal. Yes.
And main case, Millard, is Millard, I felt seriously, Millard, I, against the water fall, Millard, and civil yards. It is even a title should have filed by respondent, and that cause the, Millard, decreed against me, against us, Millard, expert. English, then we have filed appeal, and appeal is numbered. Then it was transferred to some of the other court. Then what happened immediately without me not hearing personal law, the case is dismissed. My prayer, I has notice me going. As you know, can you see last page, Millard? He gave us 75.
It says.
There is no degree. This 75 and such like.
Mr. Rashid, you take a call. We prepared the case law, in fact, in this matter. You see, what has happened, you filed an appeal. That appeal was dismissed because the delay condonation application was dismissed. But if a title appeal is dismissed, you'll have to address us as to whether on a dismissal of the title appeal, whether a second appeal will lie or it will be revision.
Second appeal, Millard, as I have seen, probably, that there is no any degree. In this title, appeal, Millard, there is no any degree. On this method, or page 75, Millard, you can see.
There is no
Only
decree.
that was the order.
No, correct. It is not admitted. You see, even if it is not admitted, it leads to dismissal. But for dismissal, there will always be a decree prepared by the office. If you look at Order 41, in an appeal, you'll find there are 3 stages of dismissal of an appeal.
There is a I file a case, this is other Millard, there is.
No, but revision, when there is a dismissal of the appeal, that's why I said that you'll have to come prepared on this question. Because once an appeal is dismissed, You may be right. You may be right. There's no decree. Okay. Mr. A. Rashid, counsel for the applicant. No, not that. In this IE, you're right. After the last part, you see, consequently, the registry shall now register the connected CRPIO, and this is the same in the motion column. No. If there is, if it is not registered, our orders can't go into that system. It will be blocked. A matter which is not listed, the order cannot be typed there in the online system. That's why when I took up my court master immediately stood up and said it's not registered. Correct. I was just seeing the law, but I think it favors you. That's why. No, yes, you are right. You're right. If you can do it, I'll release this file today. You can go and make it tomorrow, and day after tomorrow it will come.
Then it will be on 8th.
Hmm?
8 December, Friday.
Okay, Friday. List on 8. No, and list this said application on 8/11/2023. 8/12. Yes, 33. Foundation delay. Okay.
173 days.
Okay, Mr.
What's
Uh,
the
T. Kalita for the applicant. Delay of Section 5 Limitation Act, delay of 134 days beyond the period limitation filing the connected appeal. Notice steps within 2 days, returnable on 18/1. Okay.
Much of
Item 33 is okay. 34. Uh,
34.
Non-refusing call for the applicant for existing matters since adjourned today. Let's talk for a week. 35.
There is delay of 566 day mile. There is delay of 566 day mile. It is for the first
500,
time.
then you'll have to show us why.
It is for the first time mile.
No. Notice will not be mechanically. 550 days.
566 day. And is filed from insurance file.
No, you are having some other brief then. In my copy, it is 50 days. You say 556.
In my application, 566 day. Maybe Miss Ben filed, I think.
I don't know, maybe you are having some other brief. check it up. We'll take it up after some time. Item 36.
There is a delay of 238 days.
238 days. You'll have to tell us why.
I filed into this appeal, connected appeal. On
I don't know. I think everybody is having different view. I have a different view. I don't know. Here it is 11 days delay. I don't know. Check it up.
even the delay of when I filed, then
I don't know. Here it is 11 days. If you say 211, it doesn't match. Check up.
Yes.
Item 37. Ms. Sharma, it's your matter. Item 37.
There is delay of 50 days only. There is delay of
No. Again, something wrong.
37.
This is 531 days. Please check up. 38.
50 days, 8 days, 58 days.
58.
Because it ma'am, that we are, so we are keen to settle this case, can we listed for the next upcoming order? We are ready to settle this case. I have, right now, I've got a discussion from the company. And there is another analogous case filed.
No, I don't know. And here there is no date given in your cost title. Please amend it. Amend it. Mr.
PJ Burman.
PJ Burman, counsel for the PJ Burman, J. Then you pay your clerk well. Here it is only P Burman. If your clerk does not know your name, that means you are you're not paying him his full fees. Mr. PJ Burman, counsel for the petitioner, is applicant, is directed to insert the quantum of delay in the cost title, which shall be done in the presence of the section and thereafter listed.
Okay.
39.
39.
Yes, Your Lordship. Lordship, I'm appealing for the respondent. He's suffering from illness of his mental health. Now he's
Suffering from?
illness of his mental health. Lordship.
Okay.
Now he's recovering. So we are willing to file an additional affidavit. Lordship. We are willing to file an additional affidavit. Lordship.
Please speak loudly. I am not hearing you. I am missing a voice.
Lordship, I am praying for some days to file an additional affidavit.
Or to file your affidavit. Oh, okay. Okay. 39. No, I think here this prayer was made for adjournment in the morning. No, for mental health, you'll have to show us something.
Yes,
Merely because of your statement, we will not adjourn it for mental health. Show me the document.
The document has sent through WhatsApp today.
Whatever be, but
Eleven 2023. I am told that next checkup is on 11, 12, 13, 12, 2023.
No. It can't be accepted. This, if you are relying on this document, it can't be accepted. He's the claimant.
Oh, I'm told.
No, he's the claimant.
Respondent.
Respondent.
He is the husband, madam, respondent.
Oh, so this is husband. Okay. Husband.
Now he's recovering from his cases. So he's willing to file an additional application.
Are you aware what has happened to him?
Then told that some semi-paralysis of his left hand also. Perhaps due to his alcoholic measure, but I have seen from the medical document, but I'm not sure also.
We'll adjourn it then.
Madam, that last chance, madam, several adjournment, they took several adjournment. Is it 2018? Last chance.
What has happened? Permanent alimony.
Ah.
She's against, you are against permanent alimony.
Yes.
That was, you are asking for enhancement or it is
Yes,
for? It's for enhancement, okay. Mr. Jay Sharma and counsel for the appellant is present and expresses urgency in the matter as the petitioner is claiming enhancement of the permanent alimony. Next, Ms. M. Boral and counsel for the respondent pays for adjournment on the ground that the respondent is under treatment. Full stop. Next, having considered that, on considering that this appeal was filed on 23/6/2017. And the matter is reluctantly adjourned for ends of justice. So it is made clear that the this matter would not be adjourned on the next date of listing. List after 2 weeks.
Right.
You see, because this tablet is for pain. For what is the pain, I don't know. One is for pressure. One, I don't know. This is something new drug. I don't know. One is for this iron deficiency. Not iron. It's thiamine. Thiamine. I think B6 deficiency. So not very convincing.
Item 40.
Yes.
The applicant is the plaintiff. It was decreed lordship on being filed by the defendant's lordship that a judgment was.
You are the plaintiff or the defendant?
Plaintiff.
Or the plaintiff.
Plaintiff's prayer is page 16, the original claim.
What is the substantial question of law in which it was admitted?
Lordship, that is on 16/12/2019. There are three supplementary questions.
Yes.
Title suit judgment issued, Lordship, or from the very beginning. Plaintiff's suit. Plaintiff's case is
You come to
that
the judgment, relevant part will understand what the matter is about.
in short, Lordship, the plaintiff's case is that Lordship, he is the patadar and along with his mother, also is a co-sharer. Later on, her name was deleted and he is the sole patadar of the entire land, Lordship, 19 beta A schedule, Lordship. And within that A schedule, Lordship, B schedule is 1 bigha. They permitted the defendant's predecessor to stay over the land and later on they are not vacating the land. So this suit for right title interest and recovery over schedule B, Lordship. Defendants.
So you're trying to project, number one, if I understood it correctly, you are saying that the defendants,
They are
they are the permissive possessor of the suit land,
Yes,
and that you are entitled to khas position of the suit land by evicting them.
by-
That is one. And you are now showing in this second appeal that there's a Khatian and Kachapata in your favor, declaring you as the owner of the said land,
yes,
correct?
yes. And exhibit 5, that is patta number 201/18, later on given to the plaintiff, Lordship, showing the name of the plaintiff. Exhibit 5. That is the patta issued in favor of the plaintiff, Lordship.
Exhibit 5 is the Patta.
Yes, Lordship.
Okay. It shows the
And non-judge.
trial court judgment first.
Defendant's objection is that Lordship, when mother's name was deleted, the sister's legal heirs were not included in the suit. So the suit is bad for non-gender of necessary party. Trial court held that Lordship, sister's legal heirs names were not Lordship reflected in the written statement. So the suit is not bad for non-gender of necessary party. So the issue was decided in favor of the plaintiff, Lordship. But the first appellate court, Lordship, in non-gender issue decided that suit is bad for non-gender of necessary parties. But later on, the first appellate court affirmed the issue 1, 2, 3 of the trial court. So the third substantial question of law. Whether by affirming the issue, the learned first appellate court reversed the non-gender issue.
Okay. Take us to the trial court judgment first.
Lordship. Page 28 issues, Lordship.
28.
Yes. Whether the suit is maintainable in law and facts, whether there is any cause of action for the suit, whether the suit is bad for non-gender.
Just wait. Your hand was too. Go. Yes.
Worship, to prove the case, plaintiff side has examined as many as 6 witnesses, including 2 official witnesses, and exhibited 5 numbers of documents. On the other hand, the defendant side examined 4 witnesses and exhibited 3 numbers of documents. Now discussion, Worship, whether the suit is maintainable with law and fact. The defendant in the instant suit alleges that the suit is not maintainable in law and facts. In the instant suit, the defendants, however, fail to mention how the suit is not maintainable. Order 8, Rule 2 of CPC says that the defendant must raise in the pleading specifically regarding the non-maintainability of the suit. I also did not find anything in the suit which renders the suit as not maintainable, hence the suit is maintainable. This issue is answered in affirmative and in favor of the plaintiff. Whether there is any cause of action for the suit. A cause of action is called the bundle of facts affirmed by one party and denied by the other. In this case, after careful perusal of entire pleading, both sides, it clearly appears before the court that the plaintiff in their claim right title interest over the entire Schedule A land and further contended that the B schedule land within the A schedule land is under illegal possession of the defendants. It is further pleaded by the plaintiff that the predecessor of the defendants were allowed to live in the Schedule B land as permissive possessor on the condition that they would vacate the suit land as and when required by the plaintiff. However, when the plaintiff now asked the defendants to vacate the Schedule B land, the same was denied, hence the plaintiff filed his present suit for declaration of his right title and interest over the entire Schedule A land. The defendant admitted that they are in possession of Schedule B land and further raised some questions of facts and laws in their written statement. The pleadings of both sides raises bona fide dispute between the parties which require proper adjudication. Hence, upon the above, it may be safely decided that the suit as cause of action, it has cause of action, the issue is answered in affirmative and in favor of the plaintiff. Whether the suit is bad for non-gender of necessary party. The defendants in the written statement allege that the suit is bad for non-gender of necessary parties as the legal heirs of deceased sisters of the plaintiff were not included as party in the suit. The defendants, however, neither mention the names of the deceased sisters of the plaintiff nor their legal heirs. Hence, the same cannot be said as a specific plea. After careful scrutiny of the entire case record, along with the evidence on record, this court also could not find names of anyone left to be included as necessary party in the incident suit, as the defendant also raised the plea but did not state the names or whereabouts of the legal heirs of the deceased sisters of the plaintiff in the evidence. As such, the plea taken by the defendant is not sustainable. Upon the above discussion, it can be safely decided that this suit is not bad for non-gender of necessary party. Hence, the issue is answered in affirmative and in favor of the plaintiff. Now, issue number 4 and 5, whether the plaintiffs has right title interest over the A schedule land and whether the defendants are the permissive possessor of the B schedule. Both the issues above are correlated and same in nature. That is why both issues above are taken together for discussion and decision. The plaintiff stated in the plain that he is the owner of the land measuring 19 bigha 0 kata 3 lessa under Satyam number 151 and in recent settlement operation. The land was recorded in his name along with his mother Aziran Nessa Dewa under Patta number 138 old and 19 new. The plaintiff also stated that later the name of his mother was expunged and thus he became the sole owner of the suit land. Plaintiff further stated in his claim that he allowed the predecessor of the defendants, with late Abdul Sheikh and Abdul Ghani Sheikh, to live in the Schedule B land, which is a part of the Schedule A land as permissible, with the condition to vacate the land when asked for. As the plaintiff averred the above facts, has the plaintiff got the burden to prove the said facts before the court.
To prove all the above facts, the plaintiff examined 6 number of witnesses and exhibited 5 numbers of documentary evidences before this court. I have carefully gone through the oral and documentary evidences where I find that.
Sorry, you have to stop. I'm not being able to concentrate. I'm getting distracted. Just wait for 5 minutes. If I can compose, that'll take up. Otherwise, I don't know. Just wait for some time. Sit down. I'm hearing her, but it is not registering. So,
Adjourn my lordship requires some rest because what if it's very tedious job. Lordship is sitting hours after hours.
no, that is okay. Let me concentrate. Let me have 5 minutes and see if I can. Because no point hearing what you call perfunctorily. That would not be good. The matter has been adjourned at the instance of the court. So, as agreed to by both sides, this is the matter on 12/12/2023. I'm sorry, still.
Not at all.
This item 35 years.
You have 50 days, madam.
50 days. Ms. L. Sharma, 50 days. Condition of yes. Next item. 36. 48 days. 248 days.
Yes, if there is a capital, number 1. What is my respond?
No, you'll have to get corrections again.
Actually, it is, while I filed, it was delayed 11 days, but it has come to the letter on, the record was not found, yes, out. When I got the, yeah, the total is 11 plus 238 days. Giving the, after filing is 238.
Oh, acha.
That is
Okay.
the thing, ma'am.
Okay.
I have
Mr. R.C. Paul and the counsel for the applicant submits that initially when the connected appeal was filed, there was a delay of 11 days. First, however, there were defects which were not rectified, and by the time the delay was the member appeal was rectified, there has been a delay of 248 days
Yes.
beyond the period of limitation
in filing this.
in filing the connected appeal. Mr. K.U. Ahmed, counsel for the
Respond.
respondent number 1, Kavita is present. Notice.
She just minor, I take the step, both ways. I'll take the step, respondent.
On respond number?
2.
Okay.
Owner of the.
You got copies?
Yes.
Applicant shall take steps for service of notice or within 2 days for service of notice on respond number 2 by registered post with AD. List. Notice is made number on 18/1/2023. List on the said date. Okay. Heavy discharge.
Matthew.
Thirty-five to the notice.
Huh?
35
Notice.
18 they did immediately.
Same 18/1. 18/1.
37.
37.
431 days,
400.
31 days.
431 days. You will have to explain the delay.
That's fine. Can explain all the time.
Uh, 500.
Oh, my lord, 431 days.
Oh, 431 days. This is L Sharma. Notice.
Obliged.
Take steps. 18/1. Take steps within 2 days.